Okay, thank you everyone for being here. I'll just use this opportunity to briefly introduce our lecturer today, Kirsten Campbell, who is lecturer in sociology at Goldsmith College, University of London, and she was the principal investigator of the European Research Council funded project, The Gender of Justice, which basically analyzed the prosecution of sexual violence in armed conflict through a case study of the International Criminal Tribunal for the former Yugoslavia and the War Crimes Chamber and Bosnian State Court. Kirsten was also a member of the Judicial Council of the Women's Court of the former Yugoslavia. So the lecture today is about a feminist approach to justice and what we can learn from the case of the Women's Court of the former Yugoslavia. In 2015, this court was held in Sarajevo and was the first women's court held in Europe, and also the first truth commission held in the region of the former Yugoslavia. So it was established by regional non-governmental organizations in order to address perceived failure of criminal and transitional justice. And it also claimed to be a new feminist approach to justice. So in this lecture seminar, Kirsten is going to explore such feminist approach to justice and what was its critique of criminal and transitional justice, and did it offer and how did it offer alternative feminist approaches to justice. So thank you, Kirsten, for being with us. I'm really very happy that you are here with us today, and I'll give you the floor.
Thank you, Yasmina, and thank you for this invite. So it's from my perspective as a member of the Judicial Council that I will introduce the idea of the Women's Court and indeed its practice. And it was, so the purpose today, as I saw it, was to give you an outline of the ideas that indeed the critiques of justice that informed the Women's Court, the models of justice that it developed, and to try and tease out what it saw as a specifically feminist approach. So what follows is quite descriptive, which is why I'm giving you PowerPoints with some apology, but this is because I thought it would be helpful to follow in terms of some of the detail. So what I'm going to first explain is Women's Court, what the Women's Court is, give you some background to its establishment, then to look at the models of justice that informed its development, and then to identify what we can see as the components of this proposed feminist approach to justice. So as Yasmina mentioned, this Women's Court was held in Sarajevo in 2015, and it was 2 days of hearings, including 4 days of public events, which, as I'll explain later, was quite important to the design of the court. There were 38 victim witnesses, meaning people who testified to harms to themselves or others, and 12 expert witnesses, who were people who put these experiences into context. 7 Judicial Council members, 4 from the so-called region, and 3 international Judicial Council members, including myself, and some 500 audience members, which we will talk about later in terms of why having this audience was important. So I think the first thing to note, as Yasmina has already mentioned, is this idea that of the establishment of a court like this. So the first thing to note is that it's the first women's court held in Europe. And this is a very specific idea of alternative justice mechanisms, which I will also explain later. specifically, it's a non-legal justice mechanism. And we, in fact, can say it's a form of truth and reconciliation, although that a model is something that it would be quite specific about what's meant by truth and what's meant by reconciliation in this context. And this is important to note because, in fact, if we describe it in this way, then the Women's Court is, in fact, the first successfully established mechanism for these, in terms of being an alternative approach to justice. What's key to the Women's Court is that it aimed to make women subjects of justice, and it aimed to make women's experiences of war central to building an alternative form of a feminist approach to justice. And I will explain why this becomes important, because it's in the context of these aims that the Women's Court tries to develop its alternative feminist approach. So the other thing I'd just like to note is that after the proceedings were held and the events were held, then the Judicial Council delivered its preliminary decisions and recommendations on the final day of the court, and also in written form, which are available, with the full judgment still to be delivered at a later date. And I also wanted just to draw your attention to the fact that the Women's Court has published both the witness testimonies and the expert witness testimonies in 2017. So, first of all, let's just put the process of establishing the Women's Court in context. Because the organisers of the court, I myself was not involved in this process. So this is how the organisers of the court described this process. But the reason why it's important to put it in this context is because that process, it was in the course of that process of developing this alternative justice mechanism from 2010 onwards, that the idea of why developing a specifically feminist approach to justice emerged. So what we see is a number of initiatives, and in fact, the organisers of the Women's Court described the Women's Court as an umbrella term for a series of initiatives from the early 1990s onwards. So they regard the process of building this different approach to justice as an integral part of designing alternative approaches. And this is very important because what we see is certain contexts and certain problems with criminal and transitional justice at various points push towards the emergence of this mechanism. So as Yasmina mentioned, this process of developing the court formally begins in 2010, and it involves at various points over 10 non-governmental organisations, with Women in Black as emerging as the lead organisation. And over the course of the process of establishing the Women's Court, what we see is the development of three critiques of existing models of justice, but also engagement with other traditions around how we think about justice. And the three models that the Women's Court drew on are formal justice, transitional justice, and people's justice. So let's have a look first at formal justice. As I mentioned, because this will be quite descriptive, I'm hoping that we have sufficient time at the end to open up questions. So the first model of justice that informs the development of the Women's Court is formal legal justice. And the Women's Court describes formal legal justice as the institutional legal system. This term primarily refers to criminal prosecutions before the ICTY from 1993 onwards, and then the national courts of the successor states from 2003 onwards, and of course with the leading court being the War Crimes Chamber of the Bosnian Court. It also refers to the ideas of state responsibility for genocide in relation to cases brought by Bosnia and Croatia against Serbia before the International Court of Justice in 1993 and 1999. The other important context for this idea of formal legal justice or the institutional legal system is the long-established prohibition in the former Yugoslavia on international crimes of genocide, war crimes against the civilian population, and what we can call traditional war crimes following the German occupation and, of course, collaborationist regimes in World War II. So there's a long-standing legal culture around prosecutions of these kinds of crimes in the former Yugoslavia. So what happens is, first of all, that the Women's Court, as part of its process of developing its alternative approach, is it first begins by diagnosing what it sees as the problem with formal legal justice. And what we see in the preparatory consultations, mainly from 2013 onwards, is a distrust and disappointment in the institutional legal system at both international and national level. And there are 6 key concerns that participants identified. Their impunity, gap between legal norms and their application, how it actually works in practice, inadequate state witness protection, institutional and community pressure and intimidation against testifying, stigmatization and harassment, particularly of survivors of sexual violence, and highly limited reparations awards. And these particular institutional failures were seen in the wider context of an increasing awareness after the past, with over 2 decades since the end of the war, of an increasing awareness of wider crimes against peace and crimes against women in particular were not being addressed in successor states in the region, and also had not been adequately addressed by the International Criminal Tribunal for the former Yugoslavia. So the diagnosis was that formal legal justice had failed to offer justice to women victims of war or create a just peace for all, including women. So the second model that they engage with is the question of transitional justice, which, as many of you will know, became an increasingly dominant model of other ways to think about what justice was in post-conflict contexts from 2000s onwards. And here we see a shift to attention from criminal prosecutions to non-legal justice measures, which in terms of the Women's Court are described as non-criminal sanctions, with ideas of restorative justice, such as healing, reconciliation, trust, symbolic reparations, as well as institutional reforms, such as lustration, material reparations, rule of law. So the Women's Court's initiative saw transitional justice as what they described as the most important attempt to overcome the limitations of the institutional legal system. And they also reflected the importance given to non-legal justice processes in the region of the former Yugoslavia. And indeed, we know that truth and reconciliation commissions are being proposed from the earliest post-war period. But it's not until 2007 that we have RECON, the first initiative being established. And that's an initiative, it's not a Truth and Reconciliation Commission as such. Now, of course, in engaging with this idea of transitional justice, looking to this non-legal approach. At the same time, leading members of the Women's Court initiatives were actively involved in RECOM, which they saw as a crucial, or as they put it, exceptionally important regional initiative. However, they also saw a significant problem with this model of transitional justice. And indeed, what their diagnosis was that a gender perspective was missing from the proposed commission, and in fact would not be able to be included with it. That as the RECOM was developing, it appeared that including a woman's or feminist perspective, not necessarily the same thing, would in fact be very difficult to achieve, to the point where it was decided it was not possible to achieve that. So the third model that they turned to, and this has two strands. And here what we see is that the Women's Court Initiative turns to alternative models of what we can call people's justice. It's this idea of justice for the people, which involves informal and non-state justice processes that aim to change existing social orders in some way. And in the context of the Women's Court, there's two key ideas. The first and most visible is the idea of women's courts or tribunals. These are feminist alternative justice mechanisms, specifically aiming to address justice for women. These feminist models of alternative justice, informal and non-legal bodies established by associations or NGOs, or in particular political movements, came out of the feminist political movement. And they're seeking justice for wrongs that are not recognised or addressed by formal legal systems. Okay, the second strand of this idea is the idea of people's justice. And this is less visible in discussions of the Women's Court, but is particularly important because it draws on the socialist legal and political culture of the former Yugoslavia. Now, Maria Riley, for example, has pointed to the importance of the self-management courts here, the idea of self-management courts. And while those courts concerned labour relations, nevertheless, there are important continuities informing the Women's Court with the socialist ideas of self-managing socialist democracy. And we see this in the ideas of the Women's Court, such as participatory democratic decision-making, self-organisation, the internationalist orientation of the non-aligned movement to the Global South, which is where the original women's courts movements emerged from, as well as broader ideas of social ownership and social solidarity. So with these three models that Women's Court was drawing from in terms of developing a specifically feminist court approach to justice, because of the critiques of transitional and transitional justice on the one hand and legal justice on the other, Women's Court drew on primarily the women's courts and tribunals approaches. At the same time, during the process of the establishment of the court, as the organisers put it, it was also recognised that this region needed to build its own context-specific approach to setting up the process and organising a women's court or tribunal, including a process that could acknowledge the specificities of each context following from each successor country. So why was it decided during this process to hold a women's court? Why was it decided to hold a women's court? Well, from the preparatory process, a number of reasons were identified. which are on the next slide. So it's to make the continuity of violence against women committed in peace and war visible, to give voice to individual experiences of women and to include those experiences in public memory, to acknowledge victim suffering, to establish facts and to put pressure on community in the institutional legal system, to understand the context of that violence and the context that made that violence possible, to satisfy the needs that institutional justice does not fulfill, to make a space for the creation of new approaches to justice, to empower women and create networks of international women's solidarity, to prevent future crimes, and to create a just peace for future generations. So, in essence, this was the aim. We will organise a women's court for the former Yugoslavia as a space for testifying and for the voices of women, for the autonomy of women, through their active participation in building justice and peace in order to create new paradigms of justice. So from this preparatory process, there emerged what the Women's Court describes as the feminist approach to justice. And I would argue that these fall into 5 categories. The idea of transformative feminist justice, the idea of gender-based harms, the idea of feminist justice proceedings, the idea of feminist judgment, and the idea of feminist subjects of justice. So let's first look at this idea of transformative feminist justice. So the first characteristic of this idea of transformative feminist justice is that it's a concept of justice that's grounded in addressing concrete injustice rather than an abstract concept of justice. So rather than beginning with abstract norms of this is what justice looks like, instead it begins by asking what are the concrete injustices that the women who are engaged in this process identify for us. So the idea is that it grounds its conceptualization of justice in the particular circumstances of social life that give rise to concrete claims of justice. The second characteristic of this concept of justice is that it is necessarily not what we can call normatively oriented to a future gender just society. And it's for this reason that the organisers emphasise the importance of concepts of transitional justice in forming this model of transformative justice, because they argue that, yes, on the one hand, transitional measures address the injustices of the past, but differently, a feminist approach to justice is oriented to a different relation to the future. That the idea is to build a just society rather than reconstructing a society as a society. So unlike transitional justice models, for example, it aims to resist restoring a society that was in fact previously unjust to women, or rebuilding a post-conflict society through so-called remasculinization. So the idea is that it aims to shape new possibilities in the present for the future. The third characteristic of this feminist approach is that it emphasizes ideas of transformative justice. Now, these ideas of transformative justice emerge in debates in transitional justice in roughly up to 2014. And they were then taken up by feminist scholars who started to talk about transformative gender justice. The idea that social transformation is necessary that does not reproduce the dependence and subordination of women that existed prior to conflict. So there is an aspect of this idea of transformative gender justice that captures the women's court. However, it does not fully capture the wider conceptualization of a justice that seeks to change power relations across the society itself. And indeed, Women's Court identified and aimed to transform what it describes as militaristic, patriarchal, ethno-nationalist, and socioeconomic social structures that produce different forms of violence against women. So gender justice is insufficient. You have to look at a wider idea of feminist justice that builds a more just society for all. So how does it start to articulate this idea of concrete injustices? Well, the first thing is to think about thematic crime, develop what it calls the thematic crimes. And that is what it begins from is not the idea of here's justice, now we're going to apply it, but what are the injustices that we can identify? This could be called a form of feminist standpoint epistemology. And it follows this approach that has been used by women's courts, which aims to construct knowledge of how we identify harms or injustices from the experiences of subordinated groups. And indeed, the methodology of the Women's Court privileges the standpoint of women's experiences, the lives and what it calls the lives and life visions of women as sources of knowledge of injustice. And the reason it does this is because it says that those experiences have not been heard or addressed in either criminal or transitional justice. So, following this principle, it builds its description of harms or crimes from the concrete experiences of injustice by women as they identify them and describe them in the preparatory process. So this approach seeks to build a description of harms from the descriptions of concrete injustices from the testimonies of the women during the preparatory process. These injustices encompass a range of physical, emotional, economic, and social harms, and are not narrowly defined. The idea is, taken collectively, these testimonies described the experiences of many women of injustice. And as such, they were seen as describing the collective experiences of women as a group. That is not to say that those women all experience the same injustices, but that this approach sought to identify the different injustices that these women experienced. And it was these personal testimonies of the individual experiences of women that form the basis of the thematic crimes which we have on the screen. And they formed what were then subsequently called the subjective elements of the crimes, or what the individual experiences were. I'll talk a bit about that more later. So the next component of this feminist approach to justice is feminist justice proceedings. So the aim of the Women's Court proceedings was to create a space which enabled women's experiences of wartime and post-war violence, including economic violence, to be heard and acknowledged publicly. So that's why, in creating this space, the organisers sought to develop what they called a number of alternative commemorative practices, both throughout Sarajevo, but also in the Bosnian Cultural Centre where the proceedings were held. These included press conferences, an opening ceremony, a peace march, what they called an artistic activist performance, and various exhibitions. The proceedings themselves took place before a large public audience, some 500 people, and that reflected the aim of the court to make the crimes against women public. Okay. Equally importantly, the physical form of the proceedings, with the witnesses on the stage and the Judicial Council with the audience. And this was supposed to emphasize the democratic horizontal nature of the proceedings. Okay, so the structure of the proceedings and the role of the participants within them adapted the methodology of women's court movement, which I talked about before, in its specific approach to feminist justice. So what this methodology does is it aims to link the subjective text, a woman's testimony, her description of what she happened to her and what she regarded as harmful, and also what she regarded as supportive or actions she took, agentic actions in the context of the situations in which she found herself. So the idea is to link this subjective text with what they describe as an objective analysis of the political, social, economic, cultural context of the violence that took place. So the proceedings consisted of the presentation of the women's testimonies, the subjective text, followed by the expert witnesses, the objective analysis in each panel. And this role of testimonial and expert witnesses is typical of women's courts. In the place of an international or national jury, which is what is normally used in women's courts methodologies, instead the women's court had an international judicial council, as I've mentioned before. So part of what's important to highlight here is, unlike criminal justice, or indeed many transitional justice proceedings or hearings, the witnesses were able to choose how they wish to give their testimony. The testimonies varied in terms of form, in terms of content, with the majority of testimonies given for about 20 minutes. During the proceedings, the witnesses explained that they had chosen to, why they had chosen to testify. They spoke about how they felt about their experiences or about testifying. And as I've mentioned, these were not just narratives of harm, but also narratives of solidarity and struggles for justice. So the witnesses described being helped by or being helped or helping others during and after the war. They described the importance of the support they received from women's organizations and other organizations during the war and the post-war period. Many of them also described their struggles for justice in terms of attempting to bring forward prosecutions, civil claims against perpetrators, claims that attempted to enforce their rights against the state. And many of these testimonies ended with a call for justice and/or a different future. And in keeping with the methodology of women's courts, the court had expert witnesses in each panel, all from the former Yugoslavia. The role of the expert witnesses, as the organisers describe it, is to assist the women's court in fully understanding the context within which the crimes and violence acts were committed. So, as described by the court, the expert witnesses explain the political, gender, social, economic, ethnic, racial, and cultural context of violence, analysing its causes and consequences, and formulating the context for individual testimonies. The idea is to show the significance of intertwining personal testimony with political analysis. So, what the expert witnesses provide is an objective, meaning a structural, political analysis of the subjective individual testimonies, aiming to provide analysis of the economic, social, and political causes and context of these crimes. Importantly, the public audience also played a crucial role in these hearings. They were not disinterested observers. in contrast to if for example, you're sitting in formal legal proceedings or even in many transitional justice proceedings. So there was a very, at many points, a very emotional exchange, a very open exchange between the public, the so-called public, and the witnesses. But it's very important to note that this public was something that was built in the process of establishing the women's court. So it shouldn't be thought of as a public out there, but as a group of people who agreed to participate in the proceedings. And indeed, the witnesses after the hearings describe this public witnessing, what many of them describe as an acknowledgement, as an active acknowledgement, as a very important aspect of their experience of the court. Now, this is could be described as public and collective witnessing, which we can talk about later. Okay, so another important component of this feminist approach to justice was the idea of feminist judgment. And you can see here that the idea is that women's court does not deliver judgments, but delivers public condemnations, with the idea of putting pressure on national and international institutions. It claimed that it could initiate appropriate measures against perpetrators of crimes, and this has not happened. However, it has collected evidence for certain reparations claims. And there is a question around how we think about what evidence and testimonies are and what role they play in formal and informal proceedings. And we can talk about further. So as I mentioned, the Judicial Council delivered an oral judgment at the conclusion of the proceedings of the court. And that preliminary decision, as it was called, began with a recognition of women as subjects of justice. And the preliminary judgment aimed to, if you can now give me 13, please, the next slide. So the preliminary judgment aimed to link the individual experience and its structural causes, as described by linking the individual testimonies and the expert witnesses. It developed the thematic crimes as an idea of system criminality, meaning systems that make criminality possible, both during the war and after the war. And it understood judgment as a political process. So not just as a description of what happened and systems, political, cultural, economic, that were responsible for these crimes, but also as a way of drawing out the politics, or the understanding the judgment as a political intervention in describing these crimes in this way. So it's not intended to be, and so on the one hand, it was absolutely intended to be a description of both the individual experience and its structural causes. It was intended to provide an analysis of the thematic crimes of system criminality, but it was also intended to be a political intervention in how we think about what the crimes were, who was responsible for them, and how to intervene in the harms that were caused by them. So another component of this feminist approach to justice is this idea of feminist subjects. So for the organisers and participants of the Women's Court, They describe this idea of women as subjects of justice, representing an attempt to bring justice to those citizens who were never considered subjects of justice, to include women's experiences in what they call the tissue of public memories and political communities, but to do so in a way that also built networks of support and solidarity. So there was an idea of the women's court, or the feminist approach to justice, as being one that would treat women as the proponents of justice, as the agents of building a new approach to justice. So not just the objects, but the subjects of this feminist approach. So we can say that there's two interconnected ideas of subject positions, or what positions were for women within this feminist approach. The first one is the idea of an agent of feminist justice. And this is the idea, as described by another member of the Judicial Council, that women shift from their position as being victims to subjects writing and editing their own testimonies and speaking out loud in front of an audience. And in the subsequent processes, witnesses themselves emphasize the importance of this shift. So the idea is that women survivors of war can become agents of justice who, working with other women, design the justice process themselves. It's not given to them. They decide their testimony and they determine what their demands for justice will be. The second idea, or second position, is that of the idea of women as political subjects. And that is the idea that by building this justice process, that women survivors of war can be enabled to become political agents and hence part of the collective process of social change. The idea is that by giving public testimony, they offer evidence of collective injustices, they name publicly unacknowledged gender-based harms, and they connect those harms to ethno-nationalist patriarchal orders in war and peace. And the idea is that this political act of naming these collective violences, not just individual but collective violences, positions the witnesses as an agent who claims justice for those harms from their society, their state, and the international community. And this is obviously a political demand. So finally, the final component of this feminist approach to justice is an idea of feminist justice as a process, not as a, and this is the idea that the hearings in Sarajevo did not mark the end of this process, but in fact, it continues today in activities such as regional witness meetings, joint consultations, and public presentations. As the organisers put it, the final event in Sarajevo did not mark the end of the process. On the contrary, it was conceived as an encouragement to continue to create new models of justice from a feminist perspective. What the continuation of that process might be is an open question. And what's more, it's a political question that remains to be answered. So this idea of a process is that it is an ongoing, both an ongoing intervention that requires for it to be taken up collectively as part of an ongoing process of remaking or transforming our current social orders. So that's why I say it's an open question and a political question that remains to be answered. Thank you, Yasmina. That's it.
Thank you, Kirsten. Thanks, everyone, for being here. This was great. Big kiss to you. And
Thank you very much for the discussion.
Thank you. You're welcome. I'll